This video is about whether your Commonwealth charge is likely to stay in the local court or go to a higher court such as the District Court. Commonwealth charges span a range of different offences. The charges are often contained in what's called the Criminal Code Acts or the Customs Acts. They're contained in corporations law or a range of other legislation. These offences are often prosecuted by the Commonwealth Director of Public Prosecutions or the CDPP. They're the government lawyers that prosecute cases. Now, Commonwealth law only has two categories of offences. There are summary offences and there are indictable offences. This is different to the New South Wales regime, which contains 4 different categories of offences. Summary offences, they're the lowest, and it goes up to Table 2 offences, which may be indictable, which means they may go up to the District Court. Then Table 1 offences, which are more likely to go up to the District Court. And then strictly indictable offences right at the top. They must go up to a higher court. They cannot remain in the local court. Summary offences in Commonwealth law are any offences which carry a maximum penalty of 12 months imprisonment or less. These offences will remain in the local court. Indictable offences carry a maximum penalty of more than 12 months. For indictable offences that carry a maximum penalty of more than 10 years imprisonment, they must go up to the higher court, that is, to the District Court. However, for indictable offences which carry a maximum penalty of 10 years or less, they may stay in the local court with the consent of the prosecutor and the defendant. In deciding whether or not a case will go up to the District Court, the CDPP will look at a range of factors, including the maximum penalty for the offence. Of course, the lower the maximum penalty, the more likely it will stay in the local court. The seriousness of the criminality involved. So they'll look at the actual offence itself, not just the charge type, and they'll see how bad the incident was. They'll also consider the need for a deterrence, that is, to deter other people in the community away from committing these types of offences and from deterring you from committing offences again in the future. They'll look at your subjective features, that is your personal features, such as whether you have a criminal record, and if so, what you have on your criminal record, your character, and anything else to do with you. It's generally better for your case to stay in the local court than to go up to the District Court for a range of reasons. The first is that the maximum penalty that can be imposed in the local court is lower. If the maximum penalty for your particular offence, for example, is 5 years or less, then the local court can only impose a maximum penalty of 12 months imprisonment. If the maximum penalty for your particular offence is over 5 years, then the local court can only impose a maximum penalty of 2 years in prison. So the likelihood of being sent to prison by the local court is lower. Also, proceedings are much faster in the local court. It can take a long time for a case in the District Court to go to a jury trial, whereas local court proceedings are generally finalised much quicker. And partly for that reason, legal costs can be a lot lower. That is, a jury trial in the District Court can be very expensive, can be very lengthy, whereas even if your matter does go to a hearing in the local court, it's usually much shorter in time and it's usually much less expensive. Another reason is that if your matter is finalised in the local court, then you have what's called a right of appeal to the District Court. You can quickly and simply appeal to the District Court, and in practice, the District Court won't give you a higher penalty. They have to warn your lawyer or warn you before they give you a higher penalty, and if they were to do that, you'd withdraw the case at that stage. If you are charged with a Commonwealth offence, your lawyer should work hard to get your case dropped at an early stage or to get your charges reduced in number and or severity at an early stage. That can make a lot of difference to the end results. They should try to persuade the CDPP, if your case is reasonably strong, to keep the case in the local courts. Again, it's much better to stay in the local court than to go up to the District Court in most cases. They should, of course, fight very hard to win your case if it does go to a defendant hearing. And where you wish to plead guilty, they need to fight hard to help you to avoid a conviction or to achieve the lowest possible penalty in your case.